assessment, then you can run that through your annual budget process. But if it's a one-shot major amount to fix a particular item or to build something, then it has to follow the special assessment procedure rather than the annual assessment procedure.
We looked at that. We looked at ourselves, tried to read the documents. We went through our manager, finally got some various opinions, and finally it came down to that the special assessment needed to follow the same procedures, was considered the same as the annual assessment, and that we put it out there and went by that according to our documents, our covenants. And it's odd because I should have brought the wording, because when you look at the wording, it's even unclear as to whether our membership needs to vote for the special assessment. Something about the board can issue a special assessment.
Once again, it'll depend on your particular wording, and so we're giving sort of the general view and general provisions, and so we can't talk about the particulars.
I've seen documents though where, in a post-Kiowa community, a special assessment procedure is very similar to the annual assessment procedure. It's, treated like an amendment to the annual budget.
But we're doing it not in our budget cycle, we're doing it now. And then we go through the same thing, including collections for delinquencies, the whole thing is treated like an annual.
I would feel much more comfortable with an attorney review on whatever you're doing moving forward.
Especially when you're talking about a big amount, the last thing you want to do is have a bunch of people pay it and then somebody challenge it. And
we did have somebody look at it apparently through our manager. Yeah, they did say that we're on that track. So, but
I just think key is get it in writing too. Whatever advice you're going to get is get it in writing.
Because we're getting a lot of pushback, and this will be our second meeting to go through this. Our first meeting having been defeated, so.
Get it in writing.
Get it in writing. That is correct.
Yes.
Analysis.
Because then you know that whatever was given to the attorney, that they have had the time to spend looking at it and analyzing it, and they're standing behind. They have now put it in writing, and they have to stand behind that opinion. A lot of things end up on the phone of, well, this is how it should be, but it's not true legal advice at that point.
Our manager consulted with their attorney, and they said this was okay. But
the manager's attorney or the association's attorney?
The association's attorney.
Well, it's probably, we don't have, as a board, we don't have an attorney that we go to directly. So does that mean we don't have an association attorney?
Well, it could be a one-time consultation. It doesn't have to be a continued relationship with an attorney or a law firm.
Right.
But I agree with what Leonard and Lauren are saying, because once you have some written legal opinion, it's something that you can share with the members, and those specifically contesting the subject proceeding or notice or whatever action you're taking, and then you also have something to fall back on and put in your files.
That's the other thing, the notice going out, because we've gone through this now the second time. We have a big meeting coming up next week, but we sent out written notices, that this is the special assessment, the special assessment meeting, you can ratify proxies, the whole business. So, and as far as notices go, we were told that the homeowners needed 10 days notice. Okay, so you mail something out, but I just heard now that you consider that 5 days after it's mailed, 10th day from that. But we mail things out, and within 2 or 3 days they receive this.
Yeah, Kiowa actually requires the minimum time frame is 10. You mail the notice 10 days before the meeting.
Okay.
No more than 50 days before the meeting.
Okay. So you can mail the notice.
So, you might want to give a little more than 10 days before a budget meeting. But
no, this has been in the air.
Maybe we want to get all the particular facts before we,
No, it's been out there. We've had a big community meeting. We're moving forward on this, but it's a very contentious issue because it's people's pocketbooks.
And those are the kind that end in court often, especially if they involve considerable amounts of money. And then the judges will often how do I want to say this politely? Well, I'll just say it directly.
Yeah.
They'll often nitpick the process
Yeah.
and find that if you didn't mail it out within the correct period of time, or you didn't have the correct mailing list, or whatever,
Right.
they may indeed invalidate what's done.
We have been after our management company, I'm not complaining about our management company now, but this board, we have a very active 5-member board, myself and 4 others. But we've really pushed our manager to give us more concrete information along the way, and it's been a fight, despite everything. We sometimes haven't gotten specifics.
I have
So-
found a lot of value in hiring an attorney for a one-time thing to come to a board meeting and, you know, have reviewed the information and go over it with the board so you really understand it, and have the board ask questions and have just a kind of an airing, which, you know, members of the community would be available to come see. That, if you have a contentious issue that has a potential of going to court, I would recommend it.
Although they're, once again, under the statute and under the law, many times attorneys will tell you that it needs to be held in an executive session,
Yes.
because some
Sure.
things get misinterpreted when you have a general meeting of the members, and, you know, plus, and the members thinks they can question the attorney, and it goes on and on and on and on, having been in those meetings many times.
It's sometimes
So-
really hard
so
to sit in that meeting
if-
and tell
if-
they're doing it wrong
there-
when
there's
others are there.
some topics that can be generally discussed, like we're talking about here, but others that are very fact and law specific, that should be just the board and the attorney.
Yeah, we've gone through that with a roofing company successfully and gotten some reimbursement lately. So we're really aware of that privacy issue, and we even have privacy issues now around it. So it's okay, but I really hear what you're saying. I wish I had kind of, maybe we had needed to do this a long time ago. However.
Excuse me, let me ask this
Ask
though,
one more
along those
question.
lines. As a homeowner
Mhm.
and, or a board
Right.
member, can you make a request that the board bring an attorney in? And is that binding, that request binding?
Well, you can make the request, but it's not binding. It's up to the board. Once again, remember the business judgment rule?
Yes.
The board can determine those items that it thinks are necessary to expend association funds on attorneys.
Okay.
Because it's not a cheap process. I mean, the
Yeah.
attorney doesn't just show up for an hour meeting and
No,
off the
there's
top
prep
of
and-
his or her head,
Yeah.
just
Yeah.
come up with an answer.
We only get
Usually
so
they
much
want to
of the good
review the
stuff.
documents,
Yeah.
and then they
That's
want
what I
to
heard.
research, and then, you know, you're talking about an expenditure of funds.
But is it unrealistic for she as a board member or me as a homeowner to go to our next meetings, whatever they might be, and say, we would like to make a formal request to have an attorney come and speak to us on this issue? And is that something that maybe ethically the board should pay attention to?
Well,
The
the board
board
should
should vote.
consider it. The
Yeah.
board should consider any requests of homeowners that are reasonably related to the board's duties and powers.
Okay.
And that doesn't mean they have to do it. And in
Right.
fact, this is one thing I meant to mention on the Nonprofit Act. I think there's a provision in the Nonprofit Act where owners can submit prior to the annual meeting topics that they wish to be included on the agenda. But you have to do it within a time period, I'm trying to think, maybe 30 days before the meeting or something, because I've had this happen where people will show up at homeowners will show up at an annual meeting and say, well, we don't like what the board's doing, we want to remove them all right here. Let's just have a vote and remove the board. And that, well, some boards would say that. I'd probably say that. I would say, hey, this is great, what's your name? Let's get the new covenant director.
Volunteer.
But that isn't the proper procedure for doing that. So, but there is a procedure by which you can, homeowner can submit items that they want considered at the annual meeting of owners for determination. There is, and Lauren mentioned this, there is also a provision in Kiowa, if you're a Kiowa community, that the homeowners can show up at a board meeting and they're entitled to speak on agenda items before the board votes.
Yeah.
So that doesn't mean that the homeowner gets 2 hours to talk about chickens, but you can get like time limit 3 to 5 minutes where the homeowners, and that's what most boards do, is they have the homeowner discussion at the beginning of the meeting, and the homeowners can comment on anything on the agenda or anything else.
Does the board have an obligation to let you know when those meetings are?
Oh, yeah.
Because we don't know
Well,
when they are.
We
Not
always do.
exactly.
How does
Yes.
Kiowa work? That's been an
Oh,
interesting
it's
issue
the
on
annual
Kiowa.
meeting.
Yeah.
The
Well,
obligations
there's
for the
not
annual
necessarily
meeting.
A board meeting, well, although I think a voluntary, I think this actually does apply under the Nonprofit Act to a voluntary association, even though you're not Kiowa. But board meetings are for the board. Owners are allowed to attend and have limited participation, but there is no requirement that an association send notice to all of the members of a board meeting. Now, what most associations will do is, they've got the second Tuesday of the month, and they post when the board meetings are so that people are aware of that. But when you think about some of the sizes of these communities, if they had to mail notice of every board meeting to every member, that would be, a big, substantial chunk of the budget. So there is no legal requirement to send notice of board meetings to all of the homeowners. The notice that all of the homeowners are entitled to is any member meeting. But, is it a good business practice to let owners know, what the regular board schedule is? Absolutely, because otherwise, how do you do that? Now, what Kiowa does require, and this would apply to most of you, but not to you guys, the agenda needs to be made available to homeowners, and that was a compromise when there was a bill that would require notice of board meetings to be sent to all homeowners, and the compromise was that the agenda would be made available. The agenda isn't necessarily finalized, a week before the meeting. Sometimes it's finalized the day of the meeting, so there's no time component to that, but to the extent that there is a written agenda, there should be hopefully extra copies, so when owners do come in, they can pick up a copy and know what's on the agenda. If it's finalized a week beforehand and there's a good place to post it, that's a good business practice as well.
I have one other very quick question.
We'll let her and then Bruce. Bruce, you've been very patient.
Okay.
Go ahead.
This is a detail, but, so we had some mailings go out about this special assessment and this meeting coming up and, time, the date, everything. And to conserve paper, the invitation to the special meeting, the special assessment, the special assessment itself was put on the back side of that invitation, and people receiving 3 papers of mail, not everybody looked at the back side. But we can say that it wasn't on purpose. We can say that we did mail that this is what the assessment is, but we're getting homeowners saying, gee, I never got that. Well, they didn't turn the paper over and look at it. I mean,
It's like they never read the covenants either.
And they never get our collection letters.
So, I'm saying let's mail out another mailing and, just say, make sure, it was mailed out, but here it is. But what is our?
I don't know of
You
any
do
law
not
that
have to.
requires you to
That does
do
not hold
one-sided
any water.
mailing.
No.
Okay.
I mean,
Fine.
typically, most associations try to conserve postage by
Yeah.
doing 2 sides. And
Okay.
if people are so
Yeah.
blind that they can't see, there's
Yeah.
something on the back of a piece of paper before they trash it. Once again, it's this world we live in of victims. Everybody's a
Right.
victim. And sort of the the NIMBY state, nanny state, whatever it is, that is encouraged at the state level.
Maybe in
So,
the future, put on the bottom,
once again, I'm not
please
talking about your
read the
particular
website as
facts,
well.
but in general, people are bound to see both sides of the page.
Thank you.
Bruce?
2 quick questions. One is, we were formed in '84 as an HOA, and it's a voluntary HOA, so how long is the exemption from Kiowa?
Well, you're exempt anyway because you're a voluntary group, right? You're not in your covenants, as I remember it.
Okay.
You're like Falcon Estates or so on, where it's whoever pays dues or the people who want to pay dues.
Right.
And we did have a court case on that, and actually got a ruling. Geez, where did that go? We got a ruling. A district court judge up in Douglas County, it was, that voluntary associations are not under Kiowa. Now, there is a little bit of confusion on that because there was a Court of Appeals case where it was sort of a voluntary association, but under the covenants that had a right to do collective action and then assess the owner that where it did the corrective action by that. Most of the older covenants have self-help remedies where if an owner has debris on their land and they don't get it all cleared off in time, then any other owner can go, or any other group can go and clear it off. And the court said, to my amazement, that might constitute a mandatory assessment and throw them under Kiowa. Except for that aberration, all voluntary associations, in my opinion, are under Kiowa. So.
Okay. And then the other question is, when I became president 3 years ago, I got 6 archive boxes of records, plus 3 more of treasurer reports.
Oh my gosh.
So isn't it easier for me, does the state have our articles of incorporation? Because I would like to look at those.
Oh, well, yeah.
Yes.
Janet,
So I can just contact the state?
You can just Google Colorado Secretary of State. There's a business division. Click on there, put your HOA's name, and the articles and the whole history of record should come up electronically.
I did that before, and it would show the ones we've submitted online, but, well, maybe.
no,
maybe
it should have the history. The
Should
very
be-
first,
should have the
actually, the
history.
very first document usually, Bruce, on the Secretary of State's list of the history, usually tends to be your Articles of Incorporation.
Okay.
Has a link to it, and you can go over.
And then, I don't think we were filed as a nonprofit, or is that by default an HOA originally submitting a declaration would be judged?
No, you
nonprofit?
should. The corporate status is you either file as a regular corporation or you file as a nonprofit. You have to check the box, and so it should say in in the listing with the Secretary of State that you were filed as a nonprofit.
And if we are nonprofit, which I would guess we are, that doesn't mean a 501c3.
No.
No, it does
Okay.
not.
Thank you.
Totally
That's
different.
no.
Well, I see some other people, so maybe, are we,
Oh,
have
yeah,
we
it's
exceeded our time here?
Yes.
Quick quick question about our specific problem. Our covenants haven't, if we do have a covenant against parking commercial vehicles on the street in view of any other, in view of any other lot, and it defines them as 3/4 ton. However, it says, or any other commercial vehicle. We cannot afford $100,000 for a lawyer, so we're hoping to get a little legal guidance here, maybe.
I'll let Lauren do that. Hey, Lauren, you want to tell them what a commercial vehicle is?
It's whatever the board has defined it as.
It's gonna be,
It's,
we've researched this many times, Lauren and I both. And I'll just tell you, I'm not gonna talk about your particular one, but once again, if there is no definition in your covenants of commercial vehicle other than maybe a weight size or something like that, the court would just follow that. If there is just no definition at all, because many of the covenants just say no commercial vehicles, then most courts would look to some other source to try to define. And typically, they first look at the dictionary, which it defines commercial and vehicle, and then they try to put the definitions together. My guess it doesn't help it a whole lot. Then they'll look to any kind of governmental regulations, and typically they'll look at license plates, CDOT, DOT regulations, or so on.
Which is a really,
Yeah.
tractor trailers are commercial vehicles under those, not the
but if
plumber.
a vehicle is under the 3/4 tons, but it's painted with wire nut, the name of the company on the telephone number is advertised below the bladders,
Well,
does
the-
that not help?
Well, it helps you, yes and no, because the third aspect is that they would look at what's called normal and customary, plain meaning by ordinary people. And would an ordinary person look at this and say it's a commercial vehicle? And the problem is, there's no way of, it depends on a particular judge. A particular judge would say a commercial vehicle was intended to be like a big dump truck or
Or
that.
the plumber's vehicles with all the equipment.
It was
wrapped.
never intended to be a guy who drove a pickup truck that sit on the side, Joe's roofing. In between there, it's sort of, your association, well, once again, amend your covenants, define commercial vehicles with specific tests, commercial signage, commercial equipment, commercial advertising, or commercial license plates. Or you try to adopt a rule in the hope that the court will enforce a rule.
But, you know, it largely depends on how the board has adopted, if the board has adopted rules and regulations that it has deemed to be appropriate for the community at large, would that fall under that definition? And, you know, it's possible that the community as a whole has decided that for our community, that kind of vehicle is not what we consider to be a commercial vehicle.
I think in our case, it's strictly up to the board. I think they're the ones who make the decision. Even though the covenants say, or any other commercial vehicle, I think they've
Yes.
determined what the definition
What that other, yeah.
Well, you can go to small claims court. Almost all covenants say that an owner can enforce covenants. If you wanted to sue whoever is doing this, you sue in small claims.
or the
You, as a homeowner,
But
covenants can be enforced by the association and by a homeowner usually. It depends on what it says.
And you would declare that the value of your property has been negatively affected, is that how
Yeah, you just generally ask the small claims court judge to enforce the prohibition against commercial vehicles, or prohibition against chickens, or prohibition.
Walk a trail.
It
doesn't.
You have to, because small claims court does have the authority, does have jurisdiction over, to issue injunctions to enforce covenants, and so you don't have to have, well, you should not have to have a dollar monetary component,
Because
because
the,
it does have
the
injunctions.
intent isn't to cause harm to that person, the intent is to stop bad behavior.
Yeah.
So
That's an injunction, that's what you can get. Well, I see Dave Munger, he's probably trying to throw us out.
No. Thank you guys.
Thank you all for coming.
So much. Get ready, it's a live bunch.
Good. Oh, okay.
And so she'll probably remember.
Okay. Mentally, right?
Well, that's not me.